Yes, hi everyone. Today I'm going to talk about a very important topic with regards to mostly unmarried couples. It could those things that I'm going to talk about may apply also to married couples. However, married couples tend to opt for a more extensive legal regime with property adjustment orders since they are married, and marriage affords this kind of protection with regards to property that is bought by married couples through marriage. However, unmarried couples um, have only, let's say, a limited scope of protection, and they can only determine the rights in a house um, according to the rules of property law, according to property law, property principles of property law. Now, let's say, for the sake of an argument, that we have an unmarried couple that have bought a house together, which means that they have contributed financially towards the lump sum of the purchase price of the house, or either the mortgage installments of the house. But the house has only been conveyed in the boyfriend's name. So, what will happen if they want to call it quits because the relationship has suffered a breakdown, and they want to determine who owns what in the property, or either one wants to sell it and the other one doesn't want to? What's going to happen? Now, the starting point is that equity follows the law, and there is a presumption that since the property has been conveyed in the boyfriend's name, that it is he's going to have the beneficial ownership as well, which means the equity, 100% of the equity. However, that's just a presumption. It does make things all the more easier for the boyfriend. However, it may be easily be rebutted by a counter presumption that there is going to be a resulting trust in favor of the girlfriend. Why a resulting trust? Because she has paid for it to the extent that she has paid, and the boyfriend is holding it in trust for her on her behalf for the percentage that she has paid, and she is basically, yes, for the percentage that she has paid. So in this case, there may be a resulting trust presumption by virtue of the financial contribution. But let's say that she has only provided 20% towards the balance of the house. The remaining 8% has been provided towards by the house by him through financial contributions. I'm talking about both parties, financial contributions, and she actually claims a bigger share. Now, we all know that you can claim a share through a constructive trust as well, through various ways. You can claim a share through a common intention and a detrimental reliance. A common intention is basically an understanding. This understanding may be proved by an express agreement or promises that they were going to share the house together, that the boyfriend said, you know what, this is going to be your house forever and everything. Or it may be inferred as well through financial contributions. And also, in the wake of more modern law, a broad range of factors may be taken into consideration in order to acquire an interest in the house for the party who is not a legal owner for a constructive trust. Not to forget that if once a common intention is proved, you also need detrimental reliance, and the detrimental reliance shouldn't, it doesn't need to be based on the property. It could be anything that made that other party change its position and relied on its detriment based on the common intention. Now, the common intention could be inferred, but may not be imputed, but it may be inferred through the conduct. Now, if, let's say, that financial contribution that she made under the circumstances, and just because they purchased the house together in a domestic context, and they were both, let's say, responsible for the mortgage of the house, or she made direct financial contributions as much as indirect financial contributions, and she made it possible for him to pay a lot more, or they had a joint account through which the payments were made towards, even though he made bigger payments with regards to the lump sum, or she lost a job in the course of the relationship, and etc., etc. Something that shows that from their conduct, even though that there wasn't something solid, let's say an express agreement, it could be inferred, let's say, from their conduct, it could be inferred that, like, if someone around the corner was just seeing them, he would have thought that they were making the payment just because, from the circumstances, it's so powerful evidence arises that actually demonstrate that they were making the payments in order to have an interest in that property and to share that interest in that property. And that property was not going to be tantamount to a strict mathematical calculation according to the financial contributions that they put in. Even though the court can infer common intention through a broad range of factors, not necessarily financial contributions. However, if they can give rise to common intention. However, if such a thing is not there, the financial contributions may be evidence through which constructive trust may be inferred. What happens in that case? There's an overlap between resulting trust presumption and a constructive trust, and there's a constructive trust just because all that background, all those domestic circumstances that I just described, show that they had a common intention to share the interest in the house. Now, how much? Well, the fact that this evidence can outweigh the resulting trust evidence is very, very important. It's important because this evidence is actually going to show that it's a constructive trust. So a resulting trust cannot apply because through the domestic relationship they had showed that they intended something more, if the inference may be drawn, something more than the 20% or the 30% which she had provided, or like that, or the money that either party had provided, something more. So the court will exclude the resulting trust because a constructive trust excludes the resulting trust and vice versa, and apply a constructive trust. And when it applies a constructive trust, because it has been said, and that's the modern, this is the modern trend. This is the trend now, that in cases of, in cases of domestic relationships, a constructive trust is usually the more correct vehicle of establishing ownership, and also in domestic relationships, if they have bought the house together and they are joint legal owners, this makes the presumption in favor of them owning the house in equal beneficial shares equally and own the house together on a 50% basis a lot more strongly to be rebutted. Now we're talking about a sole acquisition case. We're talking about a person that wants to acquire a share. Well, you got the constructive trust there, and based on all those things, then the court is going to exclude the resulting trust and the quantification. This will actually open the gateway to quantification, and through quantification, she could get a lot more than she had provided for. A lot more than the financial contribution that she had put in to the house. Now, could she get less than that? Well, if the other party proves that there was some kind of an express agreement that they were going to have a certain extent, then this is going to apply and prevail throughout the quantification regardless of any financial contributions. And she can get, like, if that's not proof though, she can get a lot more than what she had put into the house. If she can't prove that, in the worst case scenario, she will get whatever money she put in there on the basis of her resulting trust. Thanks very much for watching. Subscribe to my channel for more videos like that. Nothing in this video, by the way, is supposed to be legal advice or advice of any sort. Everything is informational. See ya.